Let's talk about the pretrial stage. The pretrial stage could be one hearing, it might be 3 hearings, it might be a dozen hearings, because a lot actually takes place at the pretrial stage. One of the more important things that can take place at the pretrial stage is your attorney has an opportunity to file motions. And some of those motions could be, for example, a motion to suppress. There may be a motion to dismiss that's filed, or a variety of other motions that may be appropriate to your particular case. Something else that's going on at the pretrial stage is that discovery and investigation are taking place. So let's kind of break those two things down. What's discovery? Discovery is a proceeding where, for example, the prosecutor has to turn over all of their evidence that they intend on using as part of the criminal prosecution. They have to turn over anything that may tend to show that you're guilty. They also have to show any evidence that may tend to show that you're not guilty. So it's very, very important to make sure that you get all of the discovery from the prosecutor. You shouldn't just rely upon what the prosecutor provides you. In addition to what the prosecutor provides you, you and your attorney should be performing your own investigation. And what might that investigation include? Obviously, you're going to want to question witnesses yourself and get your own version of what those witnesses have to say. In addition, you want to canvass the scene, photograph the scene. You want to try to find out, for example, if there's any video or social media that's out there that might not be included in the prosecutor's evidence. In addition to that, you're going to want to retain experts, if it's appropriate, to review any of the critical scientific evidence that might be a part of your case. So, for example, you might want to retain a ballistics expert. If you have a white-collar criminal case, you may need a handwriting expert. There's a whole panoply of experts that you might want to retain to assist you in mounting an effective defense. So at the pretrial stage, it's one of those times where the prosecutor and your attorney have opportunities to sit down and try to resolve your case short of going to trial. During that stage, the prosecutor will also come to your attorney with an offer to plead. And your attorney should be in a position to negotiate that offer to plead based upon the investigation that your attorney has performed to explain to the prosecutor why it is that the case that they filed may be vulnerable to attack at jury trial. In most felony cases in California, a criminal defendant also has a right to a preliminary hearing. Now, what is a preliminary hearing? Preliminary hearing is actually a proceeding where the prosecutor has to call witnesses, and that prosecutor has to satisfy the judge that there is a strong suspicion to believe a crime was committed and the defendant was the person who committed that crime. The preliminary hearing is actually a constitutional safeguard, and it's designed to make sure that there is at least good cause for the case to go to trial in the first place.